All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated.
Now, petitioner, you may proceed.
Madam Chief Justice, Associate Justices, and may it please the court. My name is Seth Connell, and I, along with my co-counsel, Nathan Mulker, represent the petitioner, Kenny Bearson. I will explain why the search and seizure at Kenny Bearson's home violated the Fourth Amendment, and my co-counsel will explain why the exclusion of a third-party confession violated his right to present a complete defense. At this time, I would like to request 2 minutes to be reserved for rebuttal.
That is approved.
Thank you. Your Honors, this case is about respecting the right against unreasonable intrusion of a place where the Fourth Amendment's protection is at its zenith, the home. The motion to suppress should have been granted, and the 13th Circuit's ruling should be reversed for the following 2 reasons. First, house guest Caroline Bearson did not have the authority to consent to a search of the home. And second, the detective did not have the lawful authority to seize the pawn shop receipt, even though it was left in plain view. To my first point that Caroline Bearson did not have the authority to consent. This court held in Payton versus New York that the Fourth Amendment draws a firm and bright line at the threshold of the home, and absent exigent circumstances or consent, police officers may not reasonably cross that threshold without a warrant. There are limited circumstances where the officers may be able to rely on the consent of a third party to search of a home, but the person who is consenting, the third party, must have the common authority to actually give the consent in order to comply with the Fourth Amendment's reasonableness requirement. The seminal case in this particular case before the court today is United States versus Matlock, where this court laid out the rule regarding common authority. In order to consent to a search of a home, a third party must have the common authority over the premises, and that is defined by the mutual use of the property, defined by joint access or control of it for most purposes.
So counsel, if I may, at the time that she gave consent, did she not have authority over the home?
No, Your Honor, she did not have authority over the home. The record in this case demonstrates that she was merely a house guest. And under this court's ruling in Minnesota versus Olson, a house guest cannot have common authority to consent to a search of the host's home. The record on pages 5 and 6 demonstrates that Caroline clearly communicated to the officers that she did not live at Kenny Bearson's home, that she had a permanent residence elsewhere, and also that the scope of her purpose on the property was limited in its nature and duration. Pages 5 and 6 show that she was—
counsel, doesn't that show that she had a common use of the common areas in the home? Obviously not Kenny's bedroom, but the officer didn't go into Kenny's bedroom, and she was more than just a infrequent. She was his sister, and she was there regularly for hours, maybe overnight, while she was recuperating from chemotherapy, correct?
Yes, Your Honor. She was there for a significant amount of time. However, the length of time that one is on a property does not define if they have authority to consent to a search. And even though Caroline is Kenny's sister, it's more the totality of the circumstances and the factors of which the police are made aware that determines whether a person on the property actually has that authority. And she told the police officers here that even though she was resting for a significant amount of time after her chemotherapy treatments, it was for a limited duration and for a limited purpose. The entire—
So counsel, did she have authority during that limited time that she was there?
No, Your Honor, because she was merely a guest on the property. She did not have the ability to consent because she was not able to use the property jointly or have right of access to it for most purposes. Under this court's ruling in Illinois versus Rodriguez, there is an assumption that the third party does not have that authority, and that the police officers have a duty to inquire when there is ambiguity in the facts. The sister
seemed to insinuate that she did in fact have control over the house at that time, of all areas except for Kenny's bedroom?
Your Honor, the record shows that she was able to use most parts of the house except for the bathroom and bedroom. However, cases where one has had a similar type of scope of ability to use the property have dealt with situations where there are more facts available to the police to determine if there is authority. One example is United States versus Goins from the Seventh Circuit. And in that situation, the girlfriend stated that she was able to come and go on the property at any point that she desired, even though she had a residence in another location. She limited the scope of her consent to most of the house except for the attic, but she also had a key to enter the premises as well. And because the police were put on notice of these facts, that she could come and go whenever she wanted to, and she had a right of access as demonstrated by that key, the Seventh Circuit said she did have the authority to consent, and there was no Fourth Amendment violation in that case. But none of those circumstances are present here. The record does not show that Caroline had a key to the premises. She did not state to the officers that she could come and go as she pleased. And in this type of situation, as Rodriguez noted, it is the government's burden to show that a third party has the authority to consent. And because of the deference that the Fourth Amendment gives and the protection for that, it would be improper to allow any house guest to consent to a search.
Well, counsel, couldn't the officers presume that she had a key? Kenny wasn't there. So either he left his door open, or she broke in, or she had a key. Isn't it more probable that she had a key and she could come, so she could come and go when she needed to?
Your Honor, it's possible, but because it is not preserved in the record, it is merely speculation at this point. And because Rodriguez expressly states that it is incumbent on the government and that the burden of proof falls on the government to show authority, and it is not preserved in this case, this court should not find that there was authority to consent. And this is a situation where, because of her express statements that she did not live here, she had a limited purpose for being here, and that she had a permanent residence elsewhere, that she put the officers on notice that there was an issue with her ability to consent. And as renowned Fourth Amendment scholar Wayne Lefebvre has noted, sometimes the facts cry out for further inquiry. And when this is the case, when there is reason to doubt, the police officers cannot ignore that doubt and proceed to search on the basis of ignorance being bliss. But even if this court finds that consent was valid, the motion to suppress still should have been granted because the plain view doctrine is not applicable in this case. This moves me to my second point, that the plain view seizure was also a violation of the Fourth Amendment. Normally, in order to make a seizure of a particular object, an officer must have a warrant. There are limited situations where an officer may be able to make a plain view seizure. However, as this court noted in Coolidge versus New Hampshire, plain view alone is never enough to justify a seizure. There must be some additional facts present by the nature of the object to justify making such a seizure without a warrant. In this case, we find there was no such justification because the object itself was not incriminating as required by this court's rulings in Coolidge and in Horton versus California. In Horton, this court laid out three particular elements that must be met in order to validate a plain view seizure that does not have a warrant. First, the officer must lawfully be in the location where he or she is at the time that they make the discovery. Second, the officer must also have the lawful right of access to the object. And third, the object's incriminating nature must be immediately apparent. The circumstances as preserved in the record do not show that this pawn shop receipt was evidence of criminal activity, but rather that it was evidence of innocuous and lawful activity in a commercial firearms transaction. This court has not exactly fleshed out what immediately incriminating means to date. However, the Sixth Circuit, in the case of United States versus Beale, lays out several factors that can assist this court in clarifying that standard. And two of those factors that are particularly relevant in this case are that there must be an association with criminal activity, and second, that the association can be determined at the moment of discovery. Because of the detective's actions and the way the investigation proceeded, it was not immediately apparent under the third element of the Horton test, and therefore the plain view seizure violated the Fourth Amendment.
Counsel, I have a question for you. Presuming that they had legal access to the premises because a person let them in and seemed to have that authority, when they understood that perhaps this potential defendant had been dishonest with them, when they understood what the nature of the crime was, the bullets that were used, the caliber of the bullets, and then they saw those exact possible items on a pawn sheet or some type of receipt that showed that they had recently been sold, wouldn't that not be a nexus to this very crime?
Your Honor, the officer may have seen a nexus between possible criminal activity and the nature of the object itself. However, as this court held in Arizona versus Hicks, the standard to invoke the plain view doctrine is not reasonable suspicion, but rather probable cause. Perhaps in this case, there may have been reasonable suspicion, but in order to invoke the doctrine to justify a plain view seizure, it must be immediately incriminating at the time that it is discovered, and no additional investigation must be necessary to corroborate the information that is contained in that particular object. For example, in Horton, the court analyzed a situation where the officer had a valid search warrant and found objects that were connected to the victim. However, he also saw that there was a fully automatic machine gun in the suspect's residence, and at the time that he saw that machine gun, he knew there was probable cause regarding its illegal nature. But in this case, the defendant in the pawn shop receipt was not immediately incriminating because additional steps were necessary. Another Sixth Circuit case, United States versus Simcoiak, addressed a situation where officers attempted to seize several rifles they believed may have been illegally modified. However, they had to consult with an ATF agent to determine if there was any illegal modification. And the Sixth Circuit stated that because it was not immediately apparent at the exact moment the officers discovered it, the plain view seizure doctrine was inapplicable, and the evidence at that point must have been suppressed because it violated the Fourth Amendment. The record shows—
Counsel, I've got another question. It may be tangential, but put aside the issue of consent. Didn't the officers have probable cause to enter the house based on use of marijuana, which is a felony in this jurisdiction? Remember, they smelled marijuana, they smelled the burning odor of marijuana, and they asked the young woman, has she been smoking? And she said yes. So didn't they have probable cause to enter that house to search for evidence of use of marijuana, active use of marijuana, regardless of consent?
No, Your Honor, because even if there is reasonable suspicion or probable cause to believe that there is contraband on the property, the police still needed a warrant to enter the premises if there was not lawful consent. Within the record, there is nothing that presents a circumstance regarding exigent circumstances, which the respondent may attempt to argue. The issues that this court has granted certiorari on and are preserved in the record is the authority to enter the premises and the nature of the plain view seizure, not if there were exigent circumstances to enter the premises.
Well, I'm not sure they need, I think the government can defend a search on any grounds, and I don't know if they're going to try here, but it strikes me that marijuana can be easily destroyed. It's burning, it can be consumed, the evidence can be destroyed, and it's a felony. And the officers had probable cause to believe that a crime was being committed right then and there on those premises, based on what they smelled and what the young woman said, acknowledged.
Your Honor, an analogous case from this court is Taylor versus United States from 1932, where prohibition agents saw there were illegal liquor bottles inside of the suspect's home, and they entered the premises to seize them. However, this court stated that even probable cause is not sufficient to break the barriers of the home, and they needed to get a warrant. The government would have to preserve in the record an exigent circumstances argument, and under Rule 24(1)(a) of this court, any argument not preserved in the record cannot be considered on appeal. To conclude, Your Honors, I see my time has expired. May I briefly conclude, Madam Chief Justice? Your Honors, to conclude, the consent was invalid because she was merely a house guest. The plain view seizure violated the Fourth Amendment because it was not incriminating at the time it was discovered. We ask this court to reverse the 13th Circuit. Thank you.
Thank you. Mr. Molitor, are you ready to proceed?
We are. Thank you, Your Honor.
You may proceed.
Thank you. Madam Chief Justice, Associate Justices, and may it please the court. My name is Nathan Moker, and I also represent the petitioner, Kenny Beerson. Your Honors, the Constitution protects the meaningful opportunity to present a complete defense, and the exclusion of a material and reliable confession of another to the crime with which the defendant is charged violates that right. I will first demonstrate that this confession meets the standards for constitutional reliability established by this court, and second, that this exclusion infringed upon a weighty interest of the defendant by denying him the opportunity to present evidence material in his own defense. To my first point, Your Honors, first, as a preliminary matter, this matter is reviewed de novo because it is a matter of constitutional interpretation, as this court granted cert, as the record indicates on page 10. This is not a question of the interpretation of the federal rules of evidence, which is under an abuse of discretion standard, but rather of the Constitution. And as this court has repeatedly affirmed, such as in California versus Tresera, the Constitution protects a meaningful opportunity to present a complete defense. And in Chambers, this court held that regardless of evidence's admission, under the state hearsay rules, the Constitution nonetheless required that that evidence be admitted. In Chambers versus Mississippi, this court set forward a number of factors to be used to determine whether or not evidence is admissible. And the test this court developed in that case was not a dispositive test, but rather one based on the totality of the circumstances, sufficient to indicate that evidence was reliable enough such that the Constitution required that the defendant have the opportunity to set forward that evidence. In Chambers, this court looked at the spontaneity of a confession, the person to whom the confession was made, the external circumstances corroborating the confession, and the nature of the confession itself to determine the reliability of the confession. The confession in this present case, just like the confession in Chambers, was made spontaneously, as the record indicates. Further, Your Honors, this confession was made to a close family member, Lara's niece. As the Ninth Circuit noted in United States versus Poland, a close family member is a person to whom a confession of a crime would have been natural and normal. And the record on this case indicates that Lara blurted out his confession, again, to a close family member of his niece. Further, Your Honors, the record in this case also indicates that Lara's confession substantiates precise information about the crime, information that would not have been public knowledge at the time in which he confessed, well before the trial. Your Honors, Lara first says that he used a .30 caliber rifle to engage in the murders. While this is a generic type of rifle, he nonetheless is providing information about the crime that was not commonly or generally known. Further, he says in his confession that he did not intend to kill the girl. This is corroborated by the fact that the record indicates at page 1 that the bullet wounds found in the murdered woman had been shot through the murdered man. So his statement that he did not intend to kill the girl corroborates the spread of bullets at the crime scene, which likewise there is no indication in the record that this information was known publicly. In addition, Your Honor, separate witnesses testified to Lara both having access to guns and being involved in the gun trade, and also being involved in the illegal drug trade. An anonymous tip had claimed that these murders occurred in a drug deal gone bad, and so his involvement in the drug trade substantiates that tip and provides further corroboration. Respondents may argue that
Mr.
Lara's...
Walker, what is the indicia of trustworthiness for his statement, considering that this is now coming to light years after the murders actually occurred, and the individual that he made this report to made no written report of it, simply went on about her business, didn't report it to anyone. So how can we be sure that this event actually occurred?
Your Honor, there are 2 points to answer your question. Firstly, as to the time frame of this confession with regard to the original murders, the record does not provide the specific dates as to when they occurred. We are told in the record that this confession occurred several months before the trial, as the record indicates at page 7, but the record does not provide further detail as to the precise time frame with regard to this confession and how shortly it occurred after the murders. But with regard specifically to Your Honor's question about the individual hearing this confession and her actions ultimately help show that she also, when she heard this confession, believed this confession to be at least probable, in that when she heard the confession, she then took steps to conceal this confession, to not report it or let her authorities know that it occurred. The ordinary criminal procedure for police officers in such a case would be to report such a confession, even in cases where perhaps reliability could be cast somewhat into doubt. And she failed to do so because of her relationship with the declarant.
Further, you say that. Go ahead, Judge.
No.
I just say you say that the reason that there was that, I won't call it a cover-up, but basically her relative didn't say anything. Couldn't that also be simply because the relative knew this was a loquacious person who, when he drank, he said a little more than he should or needed to for attention? Isn't that just as plausible?
Your Honors, the possible motivation of the individual who heard the declarant is, of course, not ultimately the basis for this court's determination. And Your Honor raises the question of the declarant's intoxication here, which is a critical issue in determining credibility and reliability. However, the intoxication of the declarant should not be used here to determine that the declarant was not trustworthy when he made this confession. As the Seventh Circuit noted in United States versus Bloch, there's an ancient and well-known adage in vino veritas, a common sense adage that many while intoxicated are more likely to be telling the truth and speaking directly. And in this case, intoxication most clearly points to the fact that the declarant spoke spontaneously, or as the record uses on page 7, that he blurted out his confession. So the fact that the declarant was intoxicated here, Your Honors, does not dispositively show that the confession was not voluntary or was not trustworthy. Rather, it is something that should have been brought to the attention of the jury, and the prosecution can have had the full opportunity to cross-examine Deputy Finster as she reported this confession to examine the level of intoxication.
Counsel, what impact on your argument does it make that the declarant recanted that confession? All right, he recanted that confession. Doesn't that undermine almost everything you've said? It casts it all into doubt. And the challenge here, of course, is that he's dead. Ordinarily, there wouldn't be a problem. He could testify. He could be cross-examined on both statements. A jury could determine which, if either, were true. But since he's dead, and all you've got is, the hearsay testimony of the first Finster, who got the first confession, and then the second officer who interviewed him, and he recanted. We don't care about their credibility. We care about the person who's dead, and the jury couldn't ascertain that. So doesn't that make the whole thing unreliable?
Your Honor, this confession is not made unreliable by his later attempt at recantation. The declarant in Chambers versus Mississippi likewise sought to later retract his earlier confession, but the court in that case centered on the circumstances of reliability and trustworthiness surrounding the making of the original confession itself. Those circumstances were what the court based its determination upon, not any later actions of the declarant. And I see that Justice Koo has a question, and I'd like to answer that before proceeding.
My question was the same as Judge Polster's, was the fact that he recanted later and said himself that he was intoxicated and that his statements should not be trusted. So that was the same question that Judge Polster addressed.
Thank you, Your Honor. And even if this court should determine that the question of reliability in this case is somewhat debatable, nonetheless, this court should still find that the Constitution requires the admission of this evidence. Because turning to my second point, as this court emphasized in United States versus Sheffer, the Constitution requires the admission of reliable or even debatable evidence in cases where the defendant's case is severely prejudiced by the lack of opportunity to present that evidence, where the error that occurs is not harmless, but the defendant is denied the opportunity to present its case. This court held in Rock versus Arkansas that a state exclusionary rule prohibiting the admission of hypnotically refreshed testimony violated the Constitution. Even though hypnosis's credibility is highly debatable, nonetheless, in that case, a defendant was denied the opportunity to present the only witness on a particular and central contested point in the case. Likewise, this court in Sheffer emphasized that the Constitution does require defendants have the opportunity to introduce central factual evidence to their case. And this constitutional right is only not in play when defendants are denied the opportunity to provide cumulative or bolstering evidence. Your Honors, there are two primary reasons why the evidence in this case will not be in any way cumulative or bolstering. First, this evidence provides strong affirmative evidence that another individual may have committed the crime with which Kenny Bierson has been charged. This evidence would cast into strong doubt a jury conviction of Kenny Bierson for this crime. As Justice Holmes emphasized in his dissent in United States versus Donnelly, a dissent that would go on to underlie Chambers, the confession of another to the crime with which a defendant is charged carries a high probative value and has a high likelihood of convincing any reasonable person that a defendant did not commit the crime.
But you would have to agree that the government's case is pretty strong against Kenny, with the witnesses that have come forth and said Kenny did it.
Your Honor, that leads me to my second point regarding materiality here, which is that even if this analysis is based entirely or even solely on the evidence that the prosecution set forward in the case at the district court, nonetheless, this exclusion was still material because Leopold Lara, this declarant, the record indicates that he was a close relative of Jessica Minder, one of the prosecution's primary testimonies. In other words, Your Honor, the prosecution's conviction occurred based on two witnesses and the receipt that my co-counsel has disputed. Even assuming for a moment that we lose on that first issue and the receipt is admitted, nonetheless, is based on a highly circumstantial receipt and two pieces of testimony. And this confession impeaches one of those most central pieces of testimony. It is a confession of an individual, a relative of the witness, that he, in fact, is the one committed the crime. This would carry strong impeachment value at trial and would be central to the defense's attempt to impeach this witness and cast doubts upon her credibility. Your Honors.
That goes back to Justice Poster's question about the fact that we can't actually determine the credibility of the deceased witness. So you want me to accept the credibility of one witness without being able to evaluate the credibility of another witness?
Your Honors, it is true that in this case, the declarant is, of course, deceased and unavailable. Nonetheless, the circumstances, as discussed, surrounding the nature of his confession point to a reliability sufficient to surpass that lack of availability, particularly the fact that his confession indicates specific knowledge of the crime. Further, Your Honors, as this court has frequently emphasized, it is the jury's role, especially in criminal proceedings, to be the final determiners of fact and credibility. Even in cases where credibility is somewhat doubtful, it is still nonetheless the ultimate role of the jury to make those determinations, and the jury was denied that opportunity in the case below. Your Honors, as this court emphasized...
But that gets back to my point. Even with a new trial, the jury can't determine the credibility of Mr. Lara because he's dead. All they can do is determine the credibility of the two people who received his statements and sort of weigh the circumstances. But that's like hearsay credibility. That's not the key credibility, which is Mr. Lara. When, if at all, was he telling the truth?
Your Honor, the key distinction in this case is that this confession is not being admitted in a case against Leopold Lara in order to convict him of this crime. Rather, this confession is critical here because it casts strong doubt on the conviction of Kenny Bierson for this crime and would have a high value in impeaching one of the key witnesses. Chief Justice, my time has expired. May I briefly conclude?
You may.
Your Honors, this court emphasized in Chambers versus Mississippi that the rules of evidence must not be extended to defeat the ends of justice. For these reasons, the judgment of the lower court should be reversed and this confession admitted. Thank you, Your Honors.
Thank you. Respondents, are you ready to proceed?
Yes, Your Honor.
You may proceed, Mr. Hitchcock.
Chief Justice, Associate Justices, and may it please the court. My name is Avery Hitchcock, and along with my co-counsel, Ms. Gold-Diamond, we rise on behalf of the United States, respondent in the case at bar. I'll be addressing the first question on the consensual search of the petitioner's home, and Ms. Gold-Diamond will address the second question on the excluded third-party confession. A double murder investigation, which produced incriminating evidence acquired consensually and in plain view, does not violate the Fourth Amendment. Therefore, we urge this court to affirm the decision of the 13th Circuit for two reasons. First, law enforcement reasonably believed that Caroline Bierson had the authority to grant consent to a search. And second, the receipt found on the petitioner's home was immediate probable cause of criminal activity.
Mr. Hitchcock, what are the police officers basing their reasonable belief on that Caroline had authority to grant consent to search?
Your Honor, authority is a question of facts that a trial court will analyze under the totality of the circumstances. So they look at all of the circumstances in play, the information that's made available to them, and the trial court then makes a determination about whether an officer had a reasonable belief that the individual had authority to grant consent. Now, notably, when we're here on appeal, these types of factual and evidentiary conclusions are reviewed for abuse of discretion. So here the question is whether the trial court was manifestly erroneous or manifestly unreasonable when coming to its determination. And given the great deference based off of the facts available in this case, we contend that they were. First, it was clear from the record that Caroline had a familial relationship with the petitioner. She informed the officers that Caroline was in fact Kenny Bierson's sister. And in this court in United States versus Matlock, as well as circuit courts in, for example, United States versus Ritt, the Eighth Circuit there said that a familial relationship creates a presumption of control, and thus that's a factor in favor of finding authority. Additionally, her access to the home is established by her presence in the home. The fact is that she's allowed to stay in the petitioner's home even when the petitioner himself is not present. And her stay in the petitioner's home is for indefinite durations of time while she's recovering from cancer treatments. And as the Seventh Circuit in United States versus Goins and the Eighth Circuit in United States versus Turbyville find, individuals who stayed at a residence for an indefinite duration of time, but made officers aware of that information, can often be found to have apparent authority. Now, moreover, her access to the home was established by the way that she was using the home, as though she was using it like it was her own. The fact that she felt comfortable smoking a marijuana cigarette in the living room, for example, an item that can produce a very strong odor and can have an incredible effect on the general environment of the home, indicates that she felt comfortable using the home as though it was her own.
Counsel, did not that particular young sister who was smoking marijuana, who said she didn't live there, in fact said she had a different house, isn't the fact that she was there perhaps doing something illegal? And she also said, no, you shouldn't come in or you can't come in, denied that access. But then the officers essentially told her, we're going to go get a warrant. We're going to get you in trouble. I mean, isn't that the essence of what they were suggesting? And isn't that duress or that concern, isn't that enough to cause a young woman to say, okay, come in, don't arrest me. Don't go get a warrant and get me in trouble?
No, Your Honor, respectfully, it does not. Now, you're asking questions about the voluntariness prong of consent, which, like authority, is a factual determination that we review for abuse of discretion. And while there are certain factors under that totality of the circumstances analysis that weigh in favor of the petitioner, there are other factors that weigh against that. Even being told that an officer has a lawful right to go and get a search warrant is not enough to rise to the level of coercion needed to overcome free will and be found involuntary. That's what this court has found several times. For instance, in Bumper versus North Carolina, this court was confronted with a very different question, where an individual purported to have a warrant and therefore tried to use that sort of manipulation to garner consent from an individual when they didn't actually have it. Contrasting that with this situation, this is much more like the situation in United States versus Twomey in the First Circuit or United States versus Hicks in the 11th Circuit, where police officers merely were informing Caroline of something that they had a lawful right to do. And just because she initially refused to grant consent and later changed her mind doesn't indicate the situation was coercive. It merely indicates that Caroline was willing to cooperate with police in what they were looking to do.
How would you?
Go ahead, Nick. Go ahead.
How reasonable is that belief, considering the fact that she was using marijuana? How does that affect the voluntariness of that consent, or her ability to consent for that matter?
Well, Your Honor, I suppose that could be answered in two ways. First, in terms of her capacity, the fact that she was under the influence of marijuana has no bearing. It's certainly not determinative on whether or not she had the requisite capacity to consent. While courts do sometimes consider intoxication to be a factor in analyzing the capacity, it's never been determinative. And in fact, in United States versus Willie and United States versus Contreras, individuals who were high on marijuana were found to give voluntary consent. And now the second question as to whether or not this kind of created an implicit threatening situation. Again, we would disagree with that characterization because Caroline Bierson could have still told the officers no. And the fact is that she didn't. She informed the officers of the purpose of the marijuana, that it was for a prescription. And by having that prescription, it made it legal. And now, while she wasn't able to provide the officers with documentation of that, she didn't appear to be in any sort of fear of potential arrest or other sort of civil penalties from the record. And in fact, it seemed as though she was more than willing to engage with the officers in that conversation and allow them to come in and search the home. And again, Your Honors, when we're looking at this on from an appellate viewpoint, we must give due deference to the trial court's findings on these issues, that they took into mind the fact that Caroline was under the influence of marijuana and was potentially being questioned about the marijuana use, but still found that under the totality of the circumstances, coercive practices weren't in play. And that finding—
Counsel, what do you do with the fact that when the officers had previously come and spoken to Kenny, he specifically told them they couldn't come in? All right. You're not arguing. Suppose they had come and both of them were there, Kenny and his sister, and Kenny said, don't come in. And the sister said, oh, you know, you can come in. They could not have come in because they knew it was Kenny's house, right?
Yes, Your Honor. That's the holding of this court under Georgia versus Brand.
Okay. So they knew from the owner of the house that he didn't want them in, and they took advantage of, you know, his sick teenage sister, whether she was under the influence of marijuana or not. She clearly was sick, recovered, had cancer, and just had chemotherapy. And they basically browbeat her and said, you don't let us in, we're going to get a warrant. And to a kid, that sounds like she'd get in trouble too, as my colleague said. Now, they can't get, when they know that the owner won't let them in, how are they allowed to do it this way?
Well, Your Honor, we respectfully disagree with that interpretation of the record. So first, in terms of the lack of Mr. Bierson's authority, under Fernandez versus California, this court held that an individual with actual authority's denial of consent does not last forever. It lasts while they're asking for permission to search the house and they're physically present at the house. Now, the initial refusal to grant consent was 2 months before the second version of attempting to get consent. And any other exception to the warrant requirement would render a search permissible under the Fourth Amendment at this point, whether it be a retraction of that denial of consent from the petitioner himself or another individual who had either actual or apparent authority, in this case, Caroline Bierson, or another exception to the warrant requirement. Any of those under Fernandez versus California take that initial refusal of consent out of the equation. And now when we're turning to whether or not Caroline Bierson had the requisite voluntariness to give consent, we don't believe that the police placed her in a coercive environment where they were browbeating her. They were instead merely engaging with her in a conversation, finding out who she was, what her relationship to the petitioner was, why she was staying in the home, where the petitioner was, asking if they could come in and search the home, and then asking a few questions about the marijuana. And then they merely informed her of something that they had a legal right to go and do, that if they didn't consent to a search now, they would come back with a search warrant later. That's not an implicit threat. It's merely informing an individual of something that the police officers had a lawful.
What was their basis for getting a warrant? What would they have given to me or any other judge to give them probable cause to that moment search the house? For what crime, and what specifically would they have been looking for?
Your Honor, the record doesn't necessarily clarify, but we believe there's two potential bases for the warrant. The first is just a general, not a general search, but a search of the house for information related to the murders based off of new information found by the detectives from re-interviewing the witnesses in this case. The second is a potential search for the marijuana that had been noticed while they were on the stoop. Either one of which would have justified the search into the common areas, which I'll go and address to now in the plain view doctrine. Under the plain view doctrine, for evidence to be admissible under plain view, it must satisfy a 3-element test established by this court in Coolidge versus New Hampshire. First, law enforcement must have a prior justification for their presence. Second, the information that they receive must be received within the scope of the search that they're conducting. And third, the information must be immediate probable cause of criminal activity. And now we can dispense with the first two prongs of the Coolidge analysis rather quickly. As we've been talking about for the past 10 minutes, it's our contention that the consent exception applies to this search, and the receipt was found on the kitchen table, which was within the common area of the residence that Caroline granted consent to search. Thus, we could focus our attention on the third prong about whether it's immediate probable cause. And now when we're talking about probable cause, it's important to remember that probable cause, as described by this court in Florida versus Harris, is a flexible common sense standard. And in Draper versus United States, the key question that we're asking is whether a reasonable officer would believe that there is a fair probability or a substantial chance that evidence may be related to the crime. Now, as soon as Detective Binger read through the receipt, he became aware that it immediately met this standard based off of its contents. The receipt established that Kenny Beerson, the petitioner, and somebody who was under suspicion and noticed that he was under suspicion for a double homicide based off of his prior interaction with Detective Binger, had previously had access to handguns of the same caliber that were used in a murder. And he chose to pawn them at a pawn shop less than 3 weeks after the murder, but notably less than a week after Detective Binger had spoken to him about the issue and asked for permission to come in and search the house. Now, not only does this establish access, but this timing establishes that Kenny Beerson, or at least could reasonably be inferred, was attempting to get rid of evidence that could be tied to tie him to the crime that he knew he was being suspected of, before police could come back with either a warrant or some other exception to the warrant requirement and search the home and find the weapons for themselves. Thus, its immediate apparent incriminating nature is immediately there. Now, while the petitioner might...
What is their reason? What is the probable cause for actually reading the receipt? The receipt may be there in plain view, but what's for actually picking it up and reading it? So it's not that plain unless you actually pick it up and read through it. What's their probable cause for picking it up and reading through it?
Well, Your Honor, first I'll note that it's not clear from the record whether the officers picked up the receipt or not. It is clear from the record, at least there's a clear omission of any lack of manipulation to make the contents of the receipt available. There's nothing in the record that suggests that Detective Binger had to open the receipt or shuffle through other papers to see the receipt, merely that he saw the receipt in plain view on the kitchen table. And now, in terms of reading the receipt, this court actually addressed this information tangentially in Arizona versus Hicks. As you may recall, in Arizona versus Hicks, officers entered an apartment and found stereo equipment that looked out of place in the apartment. And they were aware that there was stolen stereo equipment being reported, but no serial number was available for them to actually go in and compare it to see whether or not it was actually that stereo equipment in question. To find that out, officers then decided to manipulate the stereo equipment and make a previously non-seeable serial number visible. This manipulation is what constituted a second search and what this court was concerned about when it was talking about whether or not something was immediate, whether or not that information has to be manipulated in some way. But if officers just had to read the serial numbers, Justice Scalia explicitly said in the majority opinion that merely recording the serial numbers would not constitute a separate search because it doesn't impede on another individual privacy interest. Here we have the exact same situation. The receipt was in plain view, and all that needed to be done was to read it. And in fact, reading through a receipt often is less intensive than having to record a serial number piece by piece, because the order of the numbers and the letters that are being used will often be in small print and is crucial in order to actually track the item in question. I see my time has elapsed. May I briefly conclude, Your Honor?
You may.
We ask that this court respect the due deference given to the lower court's factual findings on these issues and affirm the decision of the 13th Circuit Court of Appeals. Thank you.
Thank you. Mrs. Gold Diamond, are you ready to proceed?
I am, Your Honor. Thank you.
You may.
Chief Justice, Associate Justices, and may it please the court. My name is Delaney Gold Diamond. I rise on behalf of the United States. This case is about the trial court's decision to exclude evidence which was unreliable, uncorroborated, and inadmissible in the petitioner's prosecution for double homicide. There are three reasons why we urge Your Honors to uphold the decision of the 13th Circuit and find the exclusion of this third-party confession did not violate the petitioner's right to present a complete defense. First, petitioner cannot overcome the abuse of discretion standard of review. Second, the evidence was not sufficiently trustworthy to fall within the Chambers Doctrine. And third, even if this court finds constitutional error, that error was harmless beyond a reasonable doubt. Now, before I proceed to my first argument about the standard of review, I want to take a moment to clarify the procedural posture of this case. Under this court's rule, Rule 14.1a, only questions set forth in the petition for cert will be considered by this court. And this court only granted cert on the question of the admissibility of the third-party confession, whether the prosecution committed misconduct is not in dispute. Moreover, prosecutorial misconduct is not a factor that courts look to determine the admissibility of a confession under either the Chambers rules or the hearsay rules. So it should be given no weight on this narrow issue of the third-party confession's admissibility. Now to turn to the standard of review. In United States versus Sheffer, this court found that a defendant's right to present evidence is not unlimited, giving federal rulemakers broad latitude under the Constitution to establish rules which exclude evidence. One of those rules is Rule 802, the rule against hearsay, which has long established that hearsay statements are presumptively inadmissible at trial. Now, this presumption can only be overcome if the petitioner can establish the statement falls within a recognized hearsay exception or the Chambers Doctrine. And the recent case in the 11th Circuit, United States versus Mitrovic, noted that the Supreme Court has never held the application of a federal rule of evidence violated a defendant's right to present a complete defense. And the federal rules governing the admissibility of hearsay are neither arbitrary nor disproportionate. And under General Electric Company versus Joyner, the trial court's decision on the admissibility of a hearsay statement is reviewed for abuse of discretion, meaning this court should give significant weight and deference to that ruling, and the ruling should not be disturbed unless petitioner can demonstrate it was manifestly erroneous. And the trial court's ruling here was not manifestly erroneous because a reasonable judge could find the statement was not sufficiently trustworthy under the Chambers Doctrine. Now, turning to the Chambers Doctrine, Chambers gives us 4 factors to determine the trustworthiness of a third-party confession. We analyze those factors under the totality of the circumstances, and each of them weighs against petitioner here. We first look to the spontaneity of the statement. Now, Your Honors, in Chambers, the court looked at 2 temporal elements of the hearsay statement. First, they looked at whether the statement was made unprovoked, whether it was elicited by questioning. And we agree that we have similar facts here, that Leopold Lara confessed to Deputy Finster without provocation. But the court in Chambers also looked to the length of time that passed between when the crime occurred and when the confession was made. In Chambers, the declarant of the hearsay statement confessed to his friend the morning after the crime took place. But here, although the record is unclear, Leopold Lara had weeks, potentially months, to think about his statement to police, which diminishes the extent to which we can rely on it. In US versus Gillette in the Second Circuit, the court similarly distinguished from Chambers, because in that case, the declarant confessed to a police officer 4 months after the alleged events occurred. And the court there found that that weighed heavily against corroboration. The second factor we look to is the availability of the witness for cross-examination. Your Honors, in the words of Professor Wigmore, cross-examination is beyond any doubt the greatest legal engine ever invented for the discovery of truth. And that engine was unavailable to the jury in this instance because Leopold Lara was not available to be cross-examined. One of the most egregious facts of Chambers is that the trial judge did not allow hearsay statements onto the record, even when that declarant was available in court for cross-examination. But here, he was unavailable to testify at trial, so the jury would not have been able to evaluate the credibility of his statement for themselves. And this strongly weighs against the admissibility of the statement. The third factor that Chambers gives us is to look to independent corroborating evidence. And there are several facts weighing against corroboration here. First, Lara could have learned his information from outside sources other than his own participation in the crime. In Rhodes versus Henry in the Ninth Circuit, the third-party confession provided information about the location of the crime, the identity of the victims, the manner of death, the number and caliber of bullets fired. But because that information could have come from public sources or gossip in the community rather than private knowledge of the crime, the Ninth Circuit did not consider those corroborating factors. And we have precisely the same facts here. While Leopold Lara was able to identify details of the crime, he could easily have acquired these details from public sources. We know the murders were highly publicized because police put up wanted posters for information. Witnesses saw those posters from a town over where the murders occurred. In fact, his own niece was actually present at the crime scene and could easily have communicated these facts to him as well. Typically, trials are public. Yes, Ron.
Was it well known that I believe the bullet passed through the driver to the girl, therefore supporting the statement that he didn't mean to kill the girl? Is that a well-known fact in public?
Your Honor, the record is silent. Of course, most trials are open to the public, and the record is unclear whether this statement was made before or after the trial, so we simply don't know. But because the petitioner is the proponent of the evidence here, it's their burden to show that the statement was sufficiently corroborated. So in a close case, we must maintain the decision of the lower court. Now, in addition, there's simply no evidence tying Leopold Lara to the crime scene. We can distinguish from Chambers here as well. In Chambers, eyewitness testimony placed the declarant of the third-party confession at the scene of the crime with a gun. Here, there are no eyewitnesses who placed Lara at the crime scene, no one who saw Lara with a gun. And in Rhodes and Gillette, the courts also looked to whether independent forensic evidence tied the declarant to the crime scene. Here we have no ballistics, no fingerprints, no DNA, no witnesses, no evidence to suggest that Lara was even at the crime scene or connected to the murder weapon at all. Furthermore, eyewitness evidence actually contradicts the confession. And this is a factor that the Seventh Circuit looked to in Charlotte versus Israel. In this case, eyewitnesses saw Kenny Beerson chase after a car, pull over, saw a dark figure grab something out of the back of Mr. Beerson's truck, and then heard loud popping sounds. The petitioner's own sister was heard screaming, "What did you do?" implying familiarity with the shooter and surprise that he had fired his gun. And petitioner's own behavior after the murders was extremely suspect as well. He menaced the eyewitnesses and told them to keep quiet about that night. Another factor that Chambers looks to is whether the confession was recanted. Now, in Christian and Rhodes, the Ninth Circuit noted that confessions which have been recanted are inherently less trustworthy, especially so when the confession was made while the declarant was drunk and later recanted when the declarant was sober. And we have the same facts here. In United States versus Caldwell, the Third Circuit found that the declarant's changing story weighed heavily against the confession's admissibility. This is true here as well, because Lara's first statement to police was entirely different from his second statement. In fact, Lara's second statement was even more serious than a recantation. Instead of denying that his confession was true, he said that Deputy Finster actually got his words wrong, meaning that whether a confession occurred at all is in dispute, not just whether the confession was recanted. And this dispute over what was said distinguishes this case from Chambers and diminishes the reliability of the confession itself. Now, to support corroboration,
isn't it pretty clear from the record that Lara's original statement was made before the trial, as opposed to after? It's a long time ago, and if so, isn't this a quintessential Brady violation? This is evidence that the police suppressed. I mean, the officer knew it. You know, I presumably because he was, the relationship, whatever, he suppressed it, and it came out only much later. Isn't this a quintessential Brady violation? And if so, and of course, had this evidence been produced timely, it would have been produced at the first trial, and then the jury could have weighed the credibility of the declarant. They would have had his first confession and then his recantation, and they could have weighed it. How can we let the state benefit from the fact that he died, given that the evidence that this exculpatory evidence was suppressed?
I have two responses to your Honor's question. First, page 7 of the record is not clear whether that first alleged confession was made before or after Kenny Bierson's trial began. So in terms of a timeline, we just don't know. The record is vague. Moreover,
right, so your adversary said it was definitely made before the trial, but you're saying the record's silent on that. Okay.
Yes, Your Honor. Page 7 of the record merely states that Deputy Finster spoke with Leopold Lara after the murders. It doesn't say whether it occurred after the trial. And again, because it is the petitioner who is the proponent of the evidence, it's their burden to show that it satisfies the reliability requirements of Chambers. Now, moreover, to address your question, Your Honor's concern about the Brady violation, under Rule 14.1 of this court, that is not an issue that this court needs to examine in order to make a determination about the admissibility of the confession. Petitioner forfeited any Brady arguments because they did not allege a Brady violation below. It's simply not in dispute today.
Okay, thank you.
Now, there are other corroborating factors that we can look to in Chambers that weigh heavily against the petitioner here. Now, petitioner argued that because the confession was made to a close family member, we should trust the confession. But there's nothing in the record to indicate that Deputy Finster was a close family member. While they were related by blood, just moments before this confession took place, Leopold Lara was shooting at Deputy Finster. There's nothing to suggest any intimacy between them other than the mere presence of a blood relationship. Moreover, looking to the self-inculpatory nature of the statement, first, as I mentioned, petitioner can't establish that the statement was against Leopold Lara's interests because they can't establish whether the statement was made at all. Again, this is more distinct, more serious than a mere recantation. When someone recants a confession, they admit, I confessed before, but I didn't mean it. Here, Leopold Lara said that Deputy Finster actually got his words wrong. This distinguishes the case from Chambers. And moreover, admissibility under the Chambers Doctrine is predicated on the assumption that people don't say things against their interest unless they believe them to be true. But that logic doesn't apply if the declarant is too intoxicated to know that the statement is against their interest. And the circuit courts have applied this logic to bar the admissibility of confessions made when the declarant was intoxicated. We see that in the Ninth Circuit in Christian versus Frank and Rhodes versus Henry, the Second Circuit in US versus Gillette, and the DC Circuit in United States versus Sheard. Here, Leopold Lara was drunk. He was so drunk, the arresting officer didn't even credit his statements and wrote them off as drunk talk. That substantially diminishes the reliability of the statements. Now, to turn to my third point, even if this court finds constitutional error here, that does not require automatic reversal. Denial of a Rule 33 motion for a new trial in light of newly acquired evidence is reviewed for abuse of discretion. And the burden is on the proponent of the new evidence to prove that that evidence is so material that it would probably produce a different verdict if the new trial was granted. In United States versus Augers, this court described that standard as a severe burden. And there are two reasons why this is a burden that petitioner cannot meet. First, we look to the strength of the prosecution's case. The prosecution presented eyewitness evidence placing Mr. Beerson at the crime scene. He owned and later pawned a murder weapon of the same caliber used in the murders. There's the statement by Mr. Beerson's younger sister. There's the fact that Mr. Beerson menaced the eyewitnesses. For the petitioner to meet their burden, they would have to demonstrate that the jury would have credited the drunk and later recanted confession told secondhand to them over the greater weight of this eyewitness testimony. And second, the confession itself did not exculpate the petitioner. Under the Ninth Circuit's analysis in Perry versus Russian and Legrand versus Stewart, a third-party confession is only harmless if that confession, if believed, would fully exonerate the defendant. And Legrand is instructive here. The court held that a third-party confession that took responsibility for the murder did not exculpate the defendant when there was physical evidence and witness testimony contradicting the confession. We have precisely the same facts here. Your Honors, both the hearsay rules and the Chambers Doctrine work to exclude evidence that's too unreliable to be admissible at trial. This court should uphold the decision of the 13th Circuit. Thank you.
Thank you. Petitioner, you reserved 2 minutes of your time for rebuttal. Are you ready to proceed?
Your Honors, I have 2 points on rebuttal today. First, to clarify a factual issue. The government asserts that this confession was revealed after the trial, but this is simply not true. Page 7 of the record shows that this was revealed several months before the reporting of the appeal. And therefore, because the appeal was timely filed within the prescribed rules for filing the appeal, it had to have been before the trial. And the government's representation on this is simply factually incorrect. Secondly, Your Honors, the government relies on the standard of review for both issues, abuse of discretion. However, in cases that involve a constitutional question, especially the right to a complete defense, de novo is the proper standard of review. Regarding motions to suppress, the circuit courts all use a de novo standard when addressing those issues as well. The petitioner in this case has not alleged any factual misfindings or assertions that were incorrect as findings by the court. These are all questions of law. Regarding Caroline's ability to consent, it's a matter of law whether she had the authority, not the nature of the facts presented. On the issue of the complete defense, we are not presenting a case regarding the admissibility under the rules of evidence, but the petition for writ of certiorari and the cert grant specifically states that the issue before this court is the right to present a complete defense. And therefore, the standard of review for both issues must be de novo and not the abuse of discretion standard. Thank you, Your Honors.
Counsel, thank you all for your arguments today. We will take this issue under advisement and render a decision in due course. Thank you for your time.
Thank you.
Thank you very much.
All rise. The Supreme Court of the United States is now in recess. Will competitors please step out of the courtroom while the justices complete their scoring sheets. We will invite the competitors back for commentary once scores are completed. Thank you very much for your time this afternoon.